Yes, hello everyone. Brighton Judge is my name. This is the Legal Forum. You understand that always we dive into the aspects of the law and we simplify the law to the fullest, to the finest. This is the barrister. You are welcome. Thank you for watching, thank you for listening, and I hope everything is well. Today I want to talk about the course unit, which is called criminal procedure. Criminal procedure, it is course unit basically studied in year 3 and year 4, but the essence of why students uh, study criminal procedure is, you see, we always go to law school, we study theories from year 1, 2, 3, 4, LDC, but in practice it is another thing. So criminal procedure, it is the kind of the course unit which teaches how practically the criminal law is practiced basically in court. Now, when you look at criminal procedure, it is the definition where the criminal laws are applied. What are the criminal laws? Criminal laws are those stipulated under the Penal Code Act of Uganda, and the Penal Code Act of Uganda shows the number of laws, shows the number of punishments at any moment when you try. Then you have to give them that number or the time, the sentencing time. Take an example: if it is murder, you may see it is 10 years and above, the felony, uh, and others. So in criminal procedure, we start by, it is wide range of series. It is not just someone is tried, but at the same point you will find a person. We have investigations. This is done by the police. We have the arrest again done by the police, and we have the appearance. This is the accused appearing in court, and we have the bail where necessary, and we have the sentencing. And after the sentencing is passed, then we can see the appeals. But in this, we have to know the purpose. The purpose, uh, we have like protecting the rights of the accused, and you have to know that the accused has rights. The accused must reach the fair trials. Not just the accused is brought in court. Actually, the accused must have, or is allowed to have a lawyer at some extent. The accused is allowed to have a lawyer, and you never know. The accused, many times the accused can win the case. You have seen those scenarios where the accused win the case. It is not a new thing. It have been happening. And before that, you have to know that the laws applicable. I have the Constitution of Uganda, 1995. We have the Magistrate Court Act, Cap 16. We have the Penal Code Act, Cap 20. We have the Title of Indictment Act, and many more others. So by this, as I've told you, if it is a criminal case, the first step is done at the police, where the police arrests the accused. After arresting the accused, they will go ahead and they will make what we call investigations in 24, in 48, in 48 hours. So they will make the investigations. After making investigations, then they will let the accused appear before the court. When the accused appear before the court, the accused will go ahead and make sure that uh, he requests for a bail under the constitution. The accused is innocent. That person is innocent until him being proven guilty. He still has that protection of innocence that you must prove beyond reasonable doubt. That is the work of the prosecution, to prove beyond reasonable doubt, to link that very person to the crime scene. Then that person may request for bail. It is either the judge in the case to give the bail or not. We have seen the case of Dr. Kizza Besigye, the current one, where we see they've been requesting for a bail, but bail not granted. Now, after some time, or after the hearing of the case, that is where we see the sentencing. They may sentence or even add charges, and after then, the accused is allowed to appeal. So the accused, now who is the convict, will allow to appeal to a court of higher jurisdiction. Let's say you've been in magistrate court, then you want to appeal. Now you appeal in court, in a high court. Then you are in high court, you want to appeal, you appeal to the higher court. Appeal to the higher court. So here the question that we will ask ourselves, or the question that arises, is when the persons are brought into court, are they in the proper jurisdiction? And if they find they are not in proper jurisdiction, let's say you are supposed to be tried in a high court, then you are now in the magistrate, then they will make what we call a transfer of the case. They will transfer your case to the case of the jurisdiction, of the jurisdiction. Try the same case. Try that case. Thank you for watching. Thank you for listening. We shall add up more. Stay blessed.